last-minute reminder, remind everyone who wants to comment to sign up on the sign-up sheets. We have one right at the end of this table and one over by the coat racks. So I will be collecting those in just about 1 minute. Good evening, everybody. I hope you all can hear me. I'd like to get this meeting started if we can. How come I'm the only one sitting way up here and all you guys are out there? My name is Jim Madden. I'm an attorney with the state of Montana, and I'll be acting as a hearings examiner in tonight's meeting. A couple of housekeeping items to start out with before I announce the purpose of the meeting and the order of the presentations. We do have some sign-up sheets. I've reminded a couple times people that we will be taking names of persons who are commenting from the sign-up sheet. So I will be calling you from the sheet. So if you wish to make a presentation and I don't have your name, it's not fatal, but we would like to have it for the record. We have 30 or so names of people testifying, and I think that it's doable to have a good comment presentation with that few of people in a reasonable amount of time throughout the evening. What I am going to do is make a kind of arbitrary rule up front, is that we try to limit our individual presentations to 5 minutes, and that will make sure that everybody gets a chance to have a fair shot at a comment. I don't have a bell up here, but if you go over 5 minutes, I will request that you start to summarize. The purpose of tonight's hearing is to receive public comments on the proposed submittal of the amendments to the Kraft Pulp Mill opacity rule to the United States Environmental Protection Agency. The submittal would be done by the governor of the state of Montana, and it would be submitted to EPA as a revision to the state implementation plan. We already tried to do that. I'll have to shout. Apparently it's locked. I'll try to speak louder. The action that is being proposed tonight is an action or a decision by the governor to submit to the EPA a state regulation for inclusion in the state implementation plan. If EPA approves the state regulation, it then becomes part of the state implementation plan and becomes a federally enforceable component of the state implementation plan. Tonight's hearing is not for the purpose of taking comment on whether the opacity amendments are to be adopted as a state rule. That was an action that has already occurred by the Board of, I think it was Health and Environmental Sciences at the time, in May. So the board is not receiving the comments that you're presenting tonight. They will be submitted to the governor. Just to clarify which decision point in the state government that you're looking at. The opacity rule amendments were adopted after a public hearing by the Board of Health in May of 1995. The rule amendments are now codified in the Montana Administrative Rules at Title 16, Chapter 8, Sections 1404, 1413, and 1424. The Department of Environmental Quality is proposing that the rule amendments adopted by the board now be submitted by the governor to the EPA. If the rule amendments are submitted by the governor to EPA, EPA will then have an opportunity to approve or disapprove the rule amendments as a revision to the state implementation plan. And if EPA approves the amendments, they will become enforceable by EPA as well as the state. The department will be compiling the comments tonight and submitting them to the governor. The department will be compiling responses as well. To the extent that we are able to offer responses, we will compile those and submit those to the governor, and that will be available as a public document. Let's see. The order of presentation tonight, if you've been to a Montana rulemaking hearing, it will be slightly different than a rulemaking hearing. We are not asking parties to identify themselves as either proponents or opponents or neutrals. This is a hearing that is required under federal law. Federal procedures are slightly different. So we are simply taking names of interested parties, and in no particular order I will start calling them. With this exception, I will ask that the department start first with an outline of the reasons that is recommending that this rule be submitted to the EPA. And after the department's finished, I'll be inviting the local county government officials to comment. However many people they have, I don't know. At that point, then, I'm going to start calling from my lists, and if there are additional parties after that that want to comment, you're welcome to do it, but we'll have to get your name onto the record. So, again, let's adopt a 5-minute rule if we can. I don't think that's going to be a major problem, but if we all want to have a say on this matter and want to get out of here by 10 o'clock, which I would like to shoot for, I think we need to do that. So with that, I think I'll ask the department to come up and make their presentation. If you would, please identify yourself for the record before you present.
Good evening. My name is Charles Homer. I'm an air quality specialist with the Department of Environmental Quality. In May of 1995, the Board of Health and Environmental Sciences, the predecessor to the current Board of Environmental Review, amended ARM 16.8, 1404, 1413, and 1424. These rule amendments dealt with the opacity limitations of craft pulp mill recovery furnaces, such as its stone container. The previous versions of 16.8, 1404, 1413, and 1424 are currently contained in the Montana State Implementation Plan, or SIP. Since the SIP contains the old version of these rules, and the old versions are in conflict with the current rule, it is the department's intent to propose that the amended versions of ARM 16.8, 1404, 1413, and 1424 be adopted into the SIP to replace the old versions. It is the department's belief that it's inappropriate to have conflicting versions of the same administrative rule in effect at the same time, particularly with the amended rule being the only rule that's enforceable by the state, and the superseded rules enforceable only by the EPA. There are several considerations for the department when proposing revisions to the SIP. One consideration when adopting a SIP revision is whether the revision would compromise other portions of the SIP. Specifically, whether the proposed change would violate control plans in non-attainment areas. During the rule adoption phase, the department addressed the question of whether or not the opacity rule amendment would negatively impact the Missoula PM10 SIP. Since the rule amendments only affect the opacity limits on Stone's recovery furnaces, and all applicable PM10 mass emission limits remain in place, the department believes that it will not. Stone will not be allowed to increase PM10 emissions beyond those limits currently allowed in the SIP. The department asked the EPA if they believe the adoption of the new opacity limits would have an effect on the Missoula PM10 SIP during the rule adoption process. We received a letter indicating that the EPA did not believe that there would be a violation of the PM10 SIP. Second consideration in the SIP change process is to determine if it was adopted in a procedurally correct manner. One of the important requirements is that the department is required to notify the public, hold a public hearing, and notify the local agency of any proposed changes to the SIP. The purpose of tonight's hearing is to take those comments. The department will summarize the comments, prepare a response in those areas where it can, and present all comments and the responses to the governor for his consideration. Thank you.
The next presenter would be the representatives from the Missoula County Government, Air Pollution. And please identify yourself for the record.
My name is Jim Carlson. I'm the Director of Environmental Health for the Missoula City County Health Department. I'm here representing the department and the Missoula City County Air Pollution Control Board, which is the designated lead agency for the development of those portions of the SIP which affect Missoula. We oppose the inclusion of the modifications of the opacity rules affecting craft recovery boilers into the SIP on substantive and procedural grounds. Procedural issues. On January 18th, 1994, EPA approved the PM10 SIP for Missoula County. Attainment of the PM10 SIP was based upon, among other things, PM10 emission limits in Stone Containers Permit number 2589-M. The permit included specific emission limitations and methods of determining compliance with these limits for, among other things, recovery boilers number 3, 4, and 5. Stone objected to the inclusion of the emission limits in its permit and eventually petitioned the Montana Board of Health and Environmental Sciences for a declaratory ruling concerning the applicable standard for the number 4 recovery boiler. The Missoula City County Air Pollution Control Board then filed a motion with the State Board of Health seeking standing in the declaratory ruling process, which was denied by the board. Subsequently, the State Board of Health made a declaratory ruling which adopted Stone's position that the disputed limit did not apply and declaring a 35% opacity limit for the number 4 recovery boiler. The Missoula City County Air Pollution Control Board filed a petition for judicial review in District Court in Missoula County, and the Air Quality Division filed a petition for reconsideration before the State Board, both citing substantive and procedural errors in the board decision. Negotiations commenced between the State Air Quality Bureau and Stone. A hearing on the motion to reconsider was set for November 18th, 1994. On November 17th, 1994, Phil Schweber, chairman of the Air Pollution Control Board, set a fax to Bob Robinson, then director of the Department of Health and Environmental Sciences, a copy of which is attached to my testimony as an exhibit. The fax spelled out in detail the conditions which were considered necessary by Missoula County to properly resolve the controversy. The essence of these conditions was that the process had to be public and had to address air quality concerns. It also stated clearly the expectations that Missoula County would be given an opportunity for input and comment before a settlement was finalized. The next day, November 18th, shortly before the rehearing was scheduled to begin, the department and Stone entered into a stipulation. The stipulation provided for a new rule to be written addressing opacity limits for recovery boilers at Kraft pulp mills. There is only one Kraft pulp mill facility in the state of Montana, and it is located in Missoula County. The terms of the rule were outlined, and Stone and DHES were both restricted from making any changes in stipulation without the written consent of the other party. The stipulation also provided for a public hearing in Missoula after the stipulation was presented and accepted by the board. There was no provision for the incorporation of public comment or input into the crafting of the rule. Further, the stipulation committed the department to support Stone in the rulemaking/SIP revision process. Rulemaking was initiated in accordance with the stipulation. Amendments to the rule were adopted by the board as proposed, despite repeated strenuous objections by the Missoula public. And today, again in accordance with the November 18, 1994 stipulation, the department is asking to incorporate the new rules into the Montana State Implementation Plan. The Missoula City County Health Department and the Missoula City Air Pollution Control Board urge that these rules not be adopted into the SIP. The question of flawed process continues to plague the state in this manner. The 1990 amendments to the Clean Air Act introduced some substantive and procedural requirements which affect EPA action on SIP development and approval. All SIPs must meet certain minimum requirements to ensure that they will be adequate to attain and maintain compliance with national ambient air quality standards. The 1990 amendments to Section 110, Parens A, Parens 2 require that all SIPs must be adopted after reasonable notice and public hearing and must include certain items such as enforceable emission limits, provisions for developing data on ambient air quality enforcement. Also, according to 110 Parens A 2M, a SIP must provide for consultation and participation by political subdivisions affected by the plan. Code of Federal Regulations 51.234 provides, among other things, that a satisfactory consultation process must include the provisions to meet the following objectives: dissemination of information and education, an opportunity for regular and frequent involvement of affected governmental organizations and elected officials, and most notably, provide an opportunity for joint resolution by affected governmental organizations and individuals of key issues in the development of the revised implementation plan. We have provided testimony in July 1994 prior to rule adoption before the State Board of Health to the effect that the state must consult local government to include the rule changes in the SIP. That testimony, which stated, quote, "The Missoula Air Pollution Control Board and the city and the county of Missoula should be required to approve such SIP modifications before they can be approved by EPA," was ignored. A copy of this is also attached in my testimony. Currently, SIPs are to remain in effect until required revisions to the SIP are approved by the administrator. Our current SIP provides very limited guidance on the SIP revision process, which must be applied in a situation where the SIP is being revised to accommodate changes in administrative rules by the state. Regulatory and air quality issues. In addition to the procedural deficiencies in the proposed SIP amendment, we have objections to the amendments for regulatory and air quality reasons. 1. The opacity rule at the time of the number 4 boiler was built was very simple. It said that any source built before November 1968 was subject to a 40% opacity requirement, and any source built after 1968 was subject to a 20% opacity rule. The number 4 recovery boiler at the Frenchtown Pulp Mill, which Stone agrees was built in 1972, is governed by a 20% opacity rule that was clear and unambiguous. Additions to the mill and additions to the opacity rule have not changed that fact in any way. The air quality permit in effect during the rulemaking process, issued to and accepted by Stone Container, stated in Section 2 entitled Limitations and Conditions, sub F, Individual Conditions for Sources, item 28, quote, Stone shall not cause or authorize to be discharged into the atmosphere visible emissions that exhibit an opacity of 20% or greater based on a 6-minute average from any stack source fugitive installed or altered after November 23, 1968, unless otherwise specified per administrative rule. The point here is that the number 4 recovery was always subject to a 20% opacity requirement as a clearly stated condition of the operating permit. Number 2, the weakening of the opacity rule affecting number 4 recovery is backsliding and allows an increase in actual emissions from that source. We know that the permit allows particulate emissions of 1,253 pounds per day, with a monthly average not to exceed 928 pounds per day. We also know that Stone has testified that, quote, a 6-minute opacity limit of 20% restricts particulate limits to about 200 pounds per day. Subtracting the effective 200-pound per day limit that Stone has stipulated based on 20% opacity from the permitted limit of 1,253 pounds per day, we get 1,053 pounds per day fewer permitted emissions from Stone if the 20% opacity rule is complied with. Clearly, the 20% opacity limit is more restrictive to particulate emissions than the mass emissions limit stated in the permit. 3. There have been no documents or information presented with the proposed rules which indicate or explain the need for the rule changes. In fact, all data received from Stone to date indicates that they can comply with the 20% opacity rule with current equipment. However, failure to comply using existing equipment would not justify a rule weakening. 4. As the agency with significant responsibility for the attainment and maintenance of ambient air quality standards in Missoula County, it is difficult to garner cooperation in the reduction of emissions from transportation, other businesses, and area sources when large politically influential sources are able to increase emissions through rule change or by minor permit modifications. Clean air requires the effort of all citizens, corporate and individual. Public confidence is undermined when the public is excluded from participation in rule changes affecting a single source. In summary, there are procedural and air quality reasons for opposing the inclusion of these amendments into the SIP. The failure to provide consultation to local elected officials and the designated lead agency were entirely absent prior to and during rulemaking. As a result of failure to provide for consultation at the appropriate times, It is our opinion that there is no legal avenue to incorporate these amendments into the SIP. When an agency starts with a flawed process, the addition of layers of perfunctory meetings cannot fix the original flaw. Therefore, we ask the Department of Environmental Quality and the State Board of Environmental Review to initiate a process of amendment that provides for true consultation prior to rulemaking as required by the Federal Clean Air Act, with genuine public process consistent with the Montana Administrative Procedures Act during rulemaking. In absence of response, we remain willing to pursue our concerns through appropriate administrative and legal means. Thank you.
I would point out, if people have written materials that they want to submit, bring them up here. We are making a collection of written testimony or other documents that people want to submit. It's not necessary, in order to get it onto the record, to read verbatim from your testimony. I just broke my 5-minute rule.
We will have 2 more people testify.
Okay.
My name is Martha McLean. I'm a Deputy County Attorney with the Missoula County Attorney's Office, and I represent the Missoula City County Air Pollution Control Board in an action that's currently pending before the 4th Judicial District Court regarding the action of the State Board of Health, now known as the Board of Environmental Review, in a declaratory ruling proceeding and in adopting the administrative rules which are now proposed for incorporation into the SIP. The Air Pollution Control Board filed a petition for judicial review challenging the decision of the board in the September 1994 interpretation of 16.8-1404, which led ultimately to the modification of the rules. Stone Container intervened in that district court action, and then after some further preliminary matters, the Board of Health and the intervener asked the district court for a stay in district court pending the conclusion of the rulemaking before the board as part of wrapping up the declaratory ruling process. That stay was granted by the district court in June of 1995. The Air Pollution Control Board filed an amended petition in November of 1995 which challenged action that was taken by the board after the filing of the original petition and which asked for declaratory relief. The status of that case now is that the intervener has filed a motion to dismiss, which I have responded to on behalf of the board, or the Air Pollution Control Board. And the matter is now pending before Judge McLean, who's not related to me. The board has not responded to the amended petition. I am submitting to you this evening a copy of the first amended petition as an exhibit for the record of this hearing. The amended petition challenges the board action on a number of points, but the one that is significant this evening is that it's the position of the Air Pollution Control Board that the administrative rules which were not adopted in substantial compliance with the Montana Administrative Procedure Act. The Air Pollution Control Board has asked the district court to declare void the 1995 amendments, which are now proposed for inclusion in the SIP, and also to make findings that the September 1994 order was erroneous and and the board acted in excess of its authority in its decision, and that the order was arbitrary and capricious. Since the administrative rules were not adopted in compliance with MAPA, the SIP amendments should not be approved. MAPA, of course, implements the right of Montanans to participate in the decision-making process of the government, which is secured to them through the State of Montana Constitution. MAPA does not provide anywhere for a process the likes of which was used in the administrative rulemaking process. There is a section of Montana law, which is known as the Montana Negotiated Rulemaking Act, which does provide a process for state agencies to use whenever appropriate to resolve controversial issues prior to the commencement of the formal rulemaking action. This act specifically provides for the identification of and inclusion of interests that will be significantly affected by the rule, which is a component that was conspicuously missing from this process. The flaws in the adoption of the administrative rules will not be overcome by additional public comment or hearings, and it is for this reason that the administrative rules should not be incorporated into the SIP. Thank you.
For parties who are arriving late, we do have sign-up sheets at the end of this long table here and also over by the coat rack. We request that parties wanting to make a presentation put their name on the sheet so that we can make a record of that, and I will be calling you from the sheets.
Good evening. For the record, my name is Bill Rossback. I am an attorney in private practice. I'm a trial lawyer in private practice here in Missoula, and I also serve in the capacity of Vice Chairman of the Missoula City County Board of Health, and also in that capacity as Vice Chair of the Air Pollution Control Board. I'm not going to go through the statements that were made by Mr. Carlson, who's a member of our staff, and Ms. McLean, who's our attorney. But I'd like to highlight some points that I've made in my own statement here. First of all, this rule, plain and simply, is not a rule. The rule that you're now trying to adopt is not a rule that is valid under Montana law. It was pure and simple a settlement of a litigation that the stone container was going to lose and the Board of Health was going to lose. Secondly, this rule that you're now trying to incorporate into the SIP is, according to the 42 U.S.C. 7421 of the Clean Air Act, requires that the state consult with the lead agency. We are the lead agency in this context, and we were not consulted at all at any time with regard to this rule. The exhibit to Mr. Carlson's statement shows that we requested consultation, we requested involvement, and we were not given that opportunity until it was a done deal. Therefore, not only was this rule adopted, the new opacity rule was adopted in violation of Montana law. To incorporate this flawed rule into the SIP at the present time would therefore plainly violate the Clean Air Act, because not only were not consulted, but in fact we have unanimously voted to object to that rule, and at a meeting in February we unanimously voted to oppose incorporation of the newly amended opacity rules into the SIP. I have attached to my exhibit, as an exhibit to my statement, something which I think it deserves considerable attention by the governor before taking any action, and that is the governor's own Department of Health and Environmental Science, before it capitulated to stone on this and drafted its secret rule, had filed a petition for rehearing. I've incorporated that petition for rehearing as an exhibit, and in that petition for rehearing, the department goes through and shows how the Board of Health's ruling that the 20% capacity rule did not apply to the number 4 boiler was completely arbitrary and capricious. But instead of taking that to its course, and which it would have likely won on, it capitulated to stone. Then, after capitulating to stone, it had this agreement which could not be changed, so they went through a pro forma hearing, which was basically a sham. Nonetheless, at that hearing, the hearing officer, where we sat here, the hearing officer heard hundreds of people testify, and there was not one single shred of scientific, legal, or economic evidence which justified this rule. Why did they come up with a 30% rule? Why not 25%, 35%, 40%? There was no scientific, economic, or legal justification for that rule. You read the hearing officer's report, and you cannot find one shred of evidence which would justify that rule. Nonetheless, it was adopted pro forma as according to the deal that had been cut with stone. I think it is of great interest to us on the Air Pollution Control Board, not only the process, but also the substance of what is happening out there. I have attached to this some data from graphs that apparently what is happening now is that Stone is providing data of their daily monitoring. I've attached graphs which show the results of the daily boiler capacity monitoring, opacity monitoring, and it shows that day after day, hour after hour, Stone rarely, if ever, exceeds the 20% capacity limit. We have learned that the reason they do not exceed the 20% capacity limit is that they now are doing real-time monitoring, that they are taking the 6-minute opacity test, giving it to their operators, and because their operators now have that data, they can adjust the operation of the boilers and keep the opacity well below 20% at all times. In fact, over the last year or so, I don't believe it has gone over 20% on very, very rare occasions. And that's because there are very skilled operators at Stone, and they have the equipment, and they have the monitoring to be able to meet that 20% at all times. They now have the will to do that, apparently, but if we give them a 30% rule, which is incorporated into federal law, what will keep them from there will be no sanction for them to maintain below that 20% rule. Certainly, we commend Stone for its willingness to work and to use the data that it has to meet the go well below that 20%. So there's no reason, basically, to give them a 30% opacity rule. They don't need that rule. What we learned from Mr. Scott at a recent meeting is that they've had this equipment in place. They could have done this, given them their operators real-time monitoring as long as they've had that opacity monitoring in place, but they never had the will to do that. Now they have the will, apparently, to do that, and they can well meet that 20% rule. So there's no justification for the 30% opacity rule whatsoever, either economically, scientifically, or otherwise. The last point that I'd like to make is that there are very, very substantial evidence now that particulates, and that's what we're talking about when we're talking about opacity, that particulates have very substantial health consequences. Stone is playing a major role in particulate emission. It is one place where we have a point source. As Mr. Carlson stated, we are doing everything we can to keep road dust down. We've clamped down on wood stoves. We've made every other citizen in Missoula airshed try to meet and improve the air. And yet we're, on the other hand, turning around and letting Stone off the hook. Stone can meet that. There's no reason why Stone can't meet the 20%. There's no reason why we should do anything to give them, to eliminate them from the need to have that will to meet the 20%. Thank you very much.
Are there other presenters from the Missoula City County? No. I'll start down the comment sheets then. Again, if there are still more latecomers, we do have a comment sheet. Looks like each one of you gets your own comment sheet, the way this is working out. Or a sign-up sheet is what I'm trying to say. We would like you to put your name on the sheet and identify yourself for our written record. I have a arbitrary 5-minute rule, which I imposed and already broke about twice, but I'm kind of shooting for a neighborhood 5 minutes. Daryl Geist.
Thank you for allowing me to testify. My name is Daryl Geist, and I speak today on behalf of Montana Cheer, the Coalition for Health, Environmental, and Economic Rights based in Missoula, Montana. Cheer is comprised of 18 groups and many concerned individuals and businesses in our community and across Montana. I'd like to address my comments to the public process by which the SIP rule change is now before the public for our input. Since 1992, Stone has pressured the state to weaken pollution standards on its number 4 recovery boiler so that it would not have to expend the $5 million the company claimed was needed to come into compliance with the long-standing 20% opacity standard. When the opacity issue was contested by Stone Container, Stone's lawyers argued before the board to deny Missoula's standing, which the board agreed to. That standing was necessary to have the board gather public input and facts and consider fully the costs to be borne by the local public health and our valley environment. Prior to reaching its decision on the opacity issue, W.G. Stewart, then Stone's general manager, improperly attempted to influence the board by sending an ex parte communication to board members' homes, requesting them to consider the economic cost to be borne by the company if the board did not change the opacity standard. Stone then directed their lawyers to preclude public hearings from being held in Missoula, the affected community, which the board acceded to. After the board reached its decision, a public hearing was finally held in Missoula, which the board members, in their official capacity as stewards of the public health and environment, did not attend. David Rusoff, an attorney for your department, filed a petition for a rehearing on the board's opacity ruling, arguing that their decision was not based upon any genuine facts or credible evidence, that the board did not exercise its own independent judgment, that the board ignored plain language and applicability of the opacity rule to Stone's number 4 recovery boiler, that the board acted in excess of its authority by exempting Stone from a rule that was adopted years before with full participation by the public, and finally that the board acted in excess of its powers by basing its decision upon the possible economic and operational impacts on Stone of requiring compliance with the law. Rusoff concludes his legal briefing by stating that the board's ruling went so far as to cast, quote, doubt on the department's ability to apply and enforce its other air quality rules, unquote. We submit that the public is left breathless by this abuse of the public decision-making process, which produced an illegal ruling which the SIP now asks the public to accept. There are now 2 lawsuits that would invalidate the opacity provision submitted in the EPA if the courts so concur. The Missoula City County Air Pollution Control Board has filed suit to overturn the board's opacity ruling for violations of the Montana Administrative Procedures Act. And the U.S. EPA has initiated a federal Clean Air Act lawsuit against Stone Container, asking for a court order, quote, for a permanent injunction requiring Stone to comply immediately with the 20% opacity limit with respect to the number 4 recovery boiler, unquote, and fines of up to $25,000 per violation. Montana's Constitution requires the state to act to maintain and improve a clean and healthful environment for all Montanans. The proposed opacity rule change included in the SIP does not meet this constitutional criteria, nor does it aspire to protect our community from harmful pollutants being emitted from Stone Container's mill. It is clear that the state has given preferential treatment to Stone and neglected the health and safety concerns of the Missoula community. The public in our community has simply been shut out of the decision-making process, which we as citizens have equal rights to under the law. We ask you to strike the opacity provision for the number 4 recovery boiler contained in the proposed SIP and request that the department enter into the record a copy of the EPA's and the county's lawsuit and Attorney David Rusoff's petition. Thank you.
Ross Best.
Hello, my name is Ross Best. Several speakers earlier touched on the general problems with the process. So I'd like to address yet another source of tainting of this process, and that has to do with conflict of interest. And then in conclusion, I'd like to talk about some of the implications of the EPA enforcement action for this SIP process. As we've been told, there was a declaratory judgment proceeding that was derailed and turned into basically an informal rulemaking and negotiating procedure that ultimately put us here tonight. In 1994, when the State Board of Health and Environmental Sciences took action on that declaratory judgment proceeding, Remington Court was a member of that board. He was at that time General Manager and Corporate Secretary of Stoltz Lumber Company. Stoltz Lumber Company regularly entered into contracts with Stone Container. Stone Container purchased wood chips and sawdust from Stoltz Lumber. Stone Container is apparently just about the only buyer for such products for a fairly large area. Remington Court, when the board acted, not only voted, but he pushed the action. He made the motion to grant Stone's requested relief. When Missoula lawyer Jeremy Thain, a member of the board, proposed that the board wait a month to consider the matter because there was a voluminous record and it might be a good idea to take time to look at that, Remington Court encouraged them to do it that day. The Montana Code of Ethics at the time said that the holding of public office or employment was a public trust created by the confidence the electorate reposed in its officers and employees. The Code of Ethics said in Section 2-2-121, a state officer or state employee may not engage in a substantial financial transaction for his private business purposes with a person whom he inspects or supervises in the course of his official duties. Remington Court, acting on behalf of Stone Container, had a substantial financial interest in transactions with Stone. The state board did inspect or supervise Stone Container. But the state board and the members of the state board in declaratory judgment proceedings are judged not only by these standards, there are higher standards because the board was acting as a quasi-judicial board. Members of the board must be held to standards approximating those of judges. The U.S. Code, Title 42, Section 7428, in dealing with SIP authorization says that the state implementation plan must contain requirements that any potential conflicts of interest by members of each board or body be adequately disclosed. There was no disclosure by Remington Court of the existence of his conflict of interest. In early 1995, I addressed the state board on the question of conflict. Remington Court was present. The board spent about 30 minutes on the matter. I got to say everything I wanted to say. He apparently didn't have anything to say, nothing of substance. He didn't comment on my allegations regarding conflict of interest. Word of this conflict reached the governor. In a meeting with the governor, he invited me to draw whatever conclusions I wanted to about the reason that Remington Court was not reappointed when he applied for reappointment to the board. The conclusion I draw is that Governor Roscoe recognized the conflict of interest there. He saw that there was too intimate a financial relationship between Remington Court and Stone Container. Our right to a clean and healthful environment cannot depend upon the impartial judgment of someone with such a close financial relationship as Remington Court had with Stone. Now, the local board's lawsuit, of which you've heard earlier, depends upon the judgment that the declaratory judgment proceeding is relevant to this proceeding before you today. And I won't go through and spell it all out. I'll just tell you, I believe that the whole process is tainted. Now, to move to my second point, the implications of the EPA enforcement action for this SIP process. As Darrell Geist mentioned, the EPA has requested enforcement of the 20% rule. The EPA has requested a permanent injunction requiring Stone to comply with the rule. The EPA has requested civil penalties of up to $25,000 per day per violation of the 20% rule. If the EPA litigation succeeds, I think it's clear that this SIP change will not stand. It's not clear to me that there's any chance that the EPA is going to approve it, and I think that the state needs to take that into account. But if this EPA suit does not succeed, there's still a clear implication on the part of the EPA in this filing that the 20% rule needs to be there. Why is the EPA suing for violations of the 20% rule? Is it a mere formality? I don't think that it is. I hope that it's not. I hope that when the EPA goes to court, they're doing it because questions of health are implicated. In conclusion, I would point to a passage in this department's petition for rehearing prepared by David Russoff. Mr. Homer, at the beginning of this hearing, indicated that opacity was not the problem, that it was mass emissions of particulate. Well, Mr. Russoff, on page 30 of his petition for rehearing, said, opacity is a measurement of the general efficiency of process or control equipment. Pieces of equipment with different or no mass emission limits may have the same opacity limit. While there is an indirect relationship between opacity and mass emissions, the two limits serve different important regulatory purposes, and a mass emission limit does not negate the need for an opacity limit to ensure that equipment is operating at a level that minimizes pollution. So I'm left wondering, why did the department say in this petition for rehearing that the opacity standard had a separate reason for existing? And why are we being told tonight by the department, by the successor department, that there is no need for the opacity rule? And if it doesn't make any difference what the rule is, why have a rule at all? Why have it incorporated in the SIP at all? Why not let them put out whatever opacity they want? Thank you.
I'm not sure I can read this. Is this Hope Steck? Seek. I'm sorry.
Hi, my name is Hope Seek, and I'm speaking on behalf of Montana Cheer. Almost a year ago at the May hearing, Montana Cheer presented you with the signatures of 6,700 Missoula Valley residents, 115 businesses, and 17 groups. All of these people signed Montana Cheer's petition calling for cleaner operations at Stone Container's Frenchtown Mill. They demanded lower particulate emissions, a reduction of toxic emissions, and a reduction of chlorine use, which would in turn limit the emission of organochlorines, the most infamous being dioxin, a highly toxic and deadly chemical byproduct of bleaching operations and the burning of polyvinyl chloride plastics. Almost a year has gone by, and the people of Missoula continue to be ignored by the state. So here we are again at another hearing, which we all know is merely a formality since the decision has already been made to allow increased pollution of our air. But we are here tonight with 4,318 more signatures, representing 101 additional businesses and one additional group, who all say that enough is enough. Missoula is already in non-attainment of the SIP for particulate pollution. How then is it possible that weakening the opacity standards for the number 4 recovery boiler at Stone Container will assist us in reaching attainment? Missoula must progress along the road towards cleaner air and attainment of federal clean air standards. We cannot go backwards. So I'm here tonight as a representative of Montana Cheer with the latest stack of petitions. Perhaps the sheer number of signatures I hold will convince you of our seriousness and intent to follow this process through to the governor and to the EPA to ensure that we move forward towards cleaner air. The state cannot, in good conscience, weaken the opacity standards. We urge Governor Roscoe to deny this proposed rule change. The state has the authority to initiate new rulemaking procedures, and we as citizens have the right to petition that you do so. Therefore, we demand that a new rule be made for craft pulp mills in the SIP, which incorporates the concerns of Missoula citizens and addresses the larger issues of community health. This new rule must include more stringent, not weaker, regulation of particulate emissions. I think 6 million pounds per year from stone is enough. This new rule must also address toxic emissions and the emission of chlorine byproducts from bleaching and burning of PVC plastics at the mill. This new rule is the only way that Missoula will be able to meet attainment and, above all, be a safe and healthy place to live. Thanks.
Okay. Garen Smith?
My name is Garen Smith, for the record. I'm a professor of chemistry at the University of Montana. I'm also a member of the Missoula Missoula City County Air Pollution Control Board. I was also appointed by Governor Roscoe to the new Board of Environmental Review this last summer. I'm in the embarrassing position of having assumed that there would be an overhead projector available for me to present data, but I don't see one in the room. Could we manage to set that up? I would appreciate it. As many others in this room, I have... if there's a screen up there, that would be fine. As many others in this room, one of the driving forces in my life has been working towards clean air and clean water. In that regard, I sought appointment to the local Air Pollution Control Board and was frustrated in not being able to take my talents and get involved in the process in working on the local, or working with Stone on their pollution limitations. During the process of all this, my role as a scientist was to try to get things on a data basis so that I could help the community work towards positive solutions. I guess I'm still frustrated that there's so much contention present in this process, and tonight my testimony is offered in hopes that we will be working towards a more creative process and mutually beneficial process. You can check the record as far as my vote went with the local Air Pollution Control Board, in that I felt that the process was flawed. However, I don't want what I see as some very positive gains for the airshed to fall by the wayside in realizing that there were some grave procedural flaws in the process. So what I would like to offer tonight is first that my pledge as being on part of being a member of the new Board of Environmental Review, that I will encourage as much participation as possible from the public, and coming from Missoula, at least there will be one set of ears and one set of lips on the board that can talk after the public process has been shut down, that I think is working for the overall good. What I wanted to provide you with tonight are some snapshots of before and after the rule change as proposed for adoption into the SIP. As I said, I'm opposed to the process that was used, but I think we've learned some valuable lessons as far as what sorts of things can help the airshed. At the same time, I would like to acknowledge that Stone Container has been very cooperative in working with me towards attaining the data I need for these presentations, and has actually worked very hard to try to bring down their emissions. Despite allegations that this is a relaxation in the standards, what the data show is their performance has significantly reduced particulates in the Missoula airshed, and that's what I'm interested in. The first overhead I'll put up This shows the 24-hour average opacity data from the last 2 years, and I've included the January 96 data. I intentionally used what are dots that are probably hard to see for the 1994, and I'll highlight them a little bit. What it shows is starting in January of 94 with the light stippling, the levels that were being observed for number 4 opacity, since that's the recovery boiler most in question, were in the region generally scattered between 10 and 20% opacity. If you look very carefully, you can see there were 6 times that the 24-hour average crept over that 20% level. My understanding from talking with Jim Carlson from the local health department is if equipment malfunctions cause that exceedance, then there is a mechanism by which Stone does not have to count that as a violation of the Clean Air Act. On July 26, 1994, the boiler operators were given access to a readout that gave essentially half-second updates of the current opacity, and you can see a dramatic step down in the opacity level. And from that point on through the balance of 1994, and then with the solid line for 1995, you can see that the opacity readings are displaced downward, indicating less particulates in the airshed. That's what we're interested in. While there's been much debate over what the opacity limit has been, I think the most important lesson here is that having a short time interval and requiring the boiler operators to pay attention to that is something that we would really like to encourage. While there is a relationship between opacity and mass emissions, our lungs feel the actual particulates, so I have also compiled the data showing the daily mass emissions from recovery boiler number 4. It shows the daily permit limit at 1,253 pounds per day. You could see that in the 1994-95 period that has not been violated. You can also see the same dramatic step occurring on July 26th, where the 6-minute rule essentially displaced downward where the mass emissions per day was residing. Although there are some occasional peaks, they start from a much lower elevation, so that it means the airshed, even when they have problems out at the mill, are starting from a lower point. Again, that's in the airshed's favor, and that's what I'm trying to promote. That's a little bit dense data, so I have taken the same data and reduced it down to a bar chart per month. The light gray bars are for 1994, the darker gray bars are for 1995, and I've included the January data with the black bar over at the left. Since the change came at the end of July, again you can see this dramatic downward step. This lists total pounds of particulate into the airshed, and you can see that that's a dramatic reduction. We do need to look at both chronic and acute types exposures, so this one would look more at what the total loading of the airshed is going to be. The opacity would give us ideas of acute events. In case people are interested, as part of the record, I'm submitting the actual spreadsheet that contains the numerical values for the particulate outputs from all 3 recovery boilers. Again, the change came in July of 1994. This includes the 1993 data. And if you look, the numbers in that column below the blue line are dramatically lower. Those above are dramatically higher. Here we can see the total poundage. In the last year, Stone has managed to reduce by almost 100,000 pounds the particulates being emitted from the recovery boiler. And I would hate that any of our problems with the procedural details would somehow discourage Stone from continuing this sort of improved boiler operation, because this is what we're really after. We had heard talk about how much an electrostatic precipitator can help us. This is something that's being done right now that is helping us, no matter how long it takes to have these opacity issues settled. Stone is doing this day after day, and I think as a community we need to encourage them to continue to do so. This is working actually way below the opacity limit and reducing things down when they're running at the 4% limit. And I'm always interested in reducing the emissions no matter where they are. If they're way below the limit, then I think we need to build incentives for Stone to do even better by encouraging that sort of behavior. Here's a bar chart showing the final results for the total yearly outputs. What you can see is that in 1995, Stone operated at almost half the emissions level. They're to be soundly congratulated there and encouraged to do even better in 96. I'm trying to come up with some more ideas for how they can do that, and I hope you'll work with me, because my goals are the same as everyone else's. Get clean air in the valley. Finally, in order to answer questions of, well, now that Garen is watching the numbers so closely, did they back off on what they're putting through the boilers so the numbers would be depressed? And I've looked through the black liquor firing data. This is what they're burning in the recovery boiler. This shows the plot for 1994 and 1995. There's no dramatic step where the 6-minute opacity monitoring began. And although the levels are slightly down in 1995, they're nowhere near the percentage drop that's shown in the total particulates. What this means is that Stone has come up with a more efficient way of processing the liquor so that less particulates are emitted per pound of liquor that's burned, and that's what this final overhead shows. I've taken the pounds of particulate produced per million pounds of liquor burned. It wants to slide. There we go. And again, I've noted the July 26, 1994 date. Again, you can see a dramatic drop. You might see a couple breaks in the data. Those are outages when the plant has the boilers down for doing annual maintenance, so I don't have any ratios that I could calculate during those days. I guess I can assure the audience here that I know the numbers as well as anybody. No one could have done this plot before I did, because the actual record was missing 1 month's data that had never been noticed until I went working for it. I am a very strong believer in teamwork and using everybody's talents to solve a problem. I think the problem we need to solve is how to keep the air clean and keep people employed, and I'll do my darndest to work in that framework. I am very eager as a member of both the local and the state board to take input from people and work as responsibly as I can. I would like to publicly disclose, since Mr. Best has talked about conflict of interest, that the gathering and processing of this data has actually taken an enormous amount of time, and in support of me being able to have a graduate student do some of the data compilation for me, Stone Container has funded a air quality research student who is working on looking at not only Stone data, but also sampling air in the general air shed. I do not receive any salary from that, although I might have results that are publishable, which you could construe as some sort of public gain. I assure you that I am working for Missoula and for Montana to try to come up with good solutions. And I hope that this SIP process doesn't erode some of the headway that we've made. To my mind, it's very much more important to know what the average, or not the average, but the total load to the airshed is rather than how high the spikes are, because I think you can see from the data that the exceedances are very narrow. Instead of being 24-hour peaks with the 6-minute opacity monitoring, they're now becoming 6-minute slices, and that's definitely the most important thing to focus on. I've actually looked at individual data from half-second intervals. I've looked at 21,000 6-minute intervals, and I can assure you that most of the times that the upsets occur, they happen very quickly, and the opacity changes 10 to 15% at a step in just a 6-minute interval. So I guess I can understand somewhat Stone's position of asking for the 30%. If they respond very quickly to spikes, I don't think there's going to be much difference between the two levels. I would like to be part of a rulemaking process that tries to take into account aspects such as this, and I hope everyone will work together to do it. Thank you.
Ann Hamilton?
Hello, my name is Ann Hamilton, and I'm a resident of Missoula. I'm a mother, and I'm an attorney here in Missoula, and I'm also on the board of directors of the Montana Environmental Information Center, and I'm speaking for them tonight. Missoula has dirty air. The air in Missoula makes us sick, and common sense says that we shouldn't be doing anything to make the air worse in Missoula. I look at this picture over here on the wall, and it shows a bright, sunny, clean day. I know that there are times when you can stand on what I assume there is the Kim Williams Nature Trail and not see that scene. The air here is bad. And in a saner time, the state of Montana agreed with Missoula, and tonight they're here championing Stone's container side. But in the past, the state opposed Stone's petition in the strongest terms. And I'll be giving some quotes from Air Quality Bureau staff members later. I want to tell you about the flawed and illegal procedure that was used to get us to the point that we are here tonight in this room. When Stone first proposed this change, the state of Montana said no. After some appeals to the Board of Health, the state of Montana entered into negotiations with Stone, secret negotiations that weren't open to the public, and the result of those negotiations were a change in the rules. Mr. Jeff Chafee, who was at the time the head of the Montana State Air Quality Bureau, said the Air Quality Bureau plans to continue to work with Stone openly. That didn't happen. The state worked with Stone in closed meetings. The public was not involved. There was no public comment allowed, and the result of those meetings was that the rule was changed, and we're here now, the first time, able to give some public comment. I disagree with Mr. Homer, who said that we're now complying with the Montana Administrative Procedure Act by having this hearing. This hearing is over a rule that's a done deal, and the only reason we're having this hearing is because we're required to have the EPA approve this rule. If we didn't have the EPA if we didn't have to have the EPA sanction this rule, we probably wouldn't even have this hearing. The other thing that I want to say is that I don't believe that there was any scientific evidence put forth that I've seen in the record showing why we need to increase this opacity standard. And I will again quote Mr. Chafee, who said, "Our review of the appealed opacity standard shows that the regulation applies a 20% opacity standard to number 4 recovery boiler, and there are no exemptions provided in the rule. The Air Quality Bureau does not plan to propose relaxation of the current opacity standards." And that's exactly what they did. Now, why did they do that? I don't know. There has been no studies. There's been no scientific evidence cited. There's been nothing to show why they changed their mind. At one time, they were very opposed to this. Now they're in favor of it. Why? I don't know. I think that we should go back to the beginning. I think that this rule should be thrown out. I think we should have open hearings, and I think that this hearing here is a sham. We should have been able to comment when the whole procedure started. Missoula is very concerned with their air. We don't want to be sick any longer here. Thank you.
For 6 years, and I first became aware of the air quality problems here when I came here during the summer, and there was this horrible smell in the air. I thought it was kind of funny at first that people would put up with this. As I lived here longer, I came to understand what the chemical composition was of the foul air, and it became quite frightening. I now remember a couple of summer days waking up here these last couple of years and waking up with my eyes stinging and there being a horrible smell in the air, and understanding where that smell is coming from, which is stone container, and the composition of what I was breathing in. Right now, I'm expecting my first child. He's going to be due in August, he or she. It's about that big, 4 inches at this point, in my wife's womb. And I really am scared for what he or she will be breathing in throughout the course of his or her life. I would not wish the ingestion of poisons on the sons or daughters of the Air Quality Board, and I hope they would not wish that on us. That's all I have to say. Thank you.
Tom Fulham, did I get that right? Tom Fulham. I'll move on. If he comes in, he still has a chance. Is he right there? Okay.
I will keep my comments brief and to the point, because this has been a long meeting and it's going to go on a lot longer, I can tell. One, since day one, there have been some real problems with the whole manner in which Stone's opacity limits were increased. From a dirty backroom deal with Stone Container, to a conflict of interest on the Board of Environmental Review, to procedural irregularities in the decision-making process, to a basic failure to consult with the community affected by the rule change, this whole process has been flawed and is probably quite illegal. 2, this community is mad and frankly quite disempowered by this whole decision-making process. What right does the Board of Environmental Review have to place the profits of a Chicago-based multinational corporation over the public welfare and health rights of the residents of the Missoula Valley? 3, why do you think that Stone Container is being sued by both a federal agency and a citizens coalition? Because they are toxic polluters who are consistently violating the law in the Missoula Valley. 4, the EPA has already designated Missoula's airshed a non-attainment zone for particulates. How can the proposed weakening of the opacity limits at the mill contribute to a cleaner airshed? They can't. 5, the lawsuit by the County Air Pollution Board on violations of the Montana Administrative Procedures Act by the Board of Environmental Review should be enough to call into question this whole process. My message to you should be loud and clear. The rules change should be disallowed, and an entirely new rulemaking process should be initiated that not only hears public input before decisions are made, but that also takes into consideration the health and environmental impacts from Stone's pollution in the Missoula Valley. Thank you.
Dennis Alexander.
For the record, my name is Dennis Alexander, and I'm the Executive Director of the American Lung Association of Montana, headquartered in Helena. I'd like to focus my comments this evening on some of the documented adverse health effects of particulate pollution that serves as our basis for our opposition to the board's ruling. The American Lung Association is a nationwide organization that was founded in 1904, whose mission is the prevention of lung disease and promotion of lung health. Our medical advisory section, the American Thoracic Society, is an 11,000-member international society of physicians and scientists. In Montana, the Lung Association was organized 80 years ago in Butte to fight tuberculosis. And today we represent all people suffering from lung diseases, such as asthma and emphysema, and all those who are interested in preserving clean air to breathe. High levels of particulate pollution can produce an array of adverse health effects, ranging from temporary reduction in lung capacity to aggravation of pre-existing lung diseases, such as asthma. Children are especially at risk because of their high respiration rates and developing respiratory systems. A recent study in Utah, for example, found that hospital admissions for children due to pneumonia, pleurisy, and bronchitis were 3 times higher than normal when particulate pollution was high. Another study published in 1993, New England Journal of Medicine, showed an association between high levels of both total and fine particulate pollution and increased death rates. Authors of this study noted that of greatest concern was a mixture of fine particulates and toxic substances that are known to cause cancer, reproductive problems, high blood pressure, and nervous and immune system damage. Other recent studies, published in peer-reviewed medical and scientific journals, have demonstrated a variety of health effects from increased particulate pollution, including increased mortality from heart and lung disease, decline in lung function, increases in symptoms of respiratory disease and use of asthma medication among children, increases in school absenteeism among children, and increases in hospital emergency room visits. And I'd like to add parenthetically here that the citations for all these peer-reviewed articles are attached to this testimony. The American Lung Association of Montana believes that these findings support our position that increasing allowable levels of particulates in Missoula will only exacerbate an already unacceptable health risk. This is simply bad public health policy and should not be permitted. I want to thank you for the opportunity to make these comments this evening.
Blake Vaughn.
Good evening. My name is Blake Vaughn, and this is indomethacin. This is a drug I need to live here in Missoula, and I love Missoula enough so I keep taking the drug and I can stay. I moved here in the fall of '93 and was not here to experience that first winter of '93, '94, but I was here last year, and I experienced a severe medical problem which put me in the hospital for 3 weeks. I was in the emergency room 4 different times. I was admitted to the hospital 3 different times. My hospital bill came to over $20,000. One of the problems that they finally realized I was suffering from was pericarditis, which is an inflammation of the tissue of the heart. It's very severe. If it goes unchecked, it can actually put so much pressure on the heart that it will stop it altogether. And one of the radiologists told me that she was looking at a picture of the x-ray of my chest and that my heart was so big, she said that I should have been dead, that she normally saw that post-mortem in people my age. I'm 23 years old. I eat very well. I don't smoke. I exercise daily. I don't own a car. I bike all the time, everywhere. I used to hike Mount Sentinel 3, if not 4 times a week. This should not be happening to me. I was hoping that the problem would have been just a thing of the past after last year, but this year, just a couple weeks ago, I noticed the same pain coming back to my chest, and I went back to the health services and had some x-rays done and all the tests that I was very familiar with, and indeed, the pericarditis had come back. I've never experienced any health trauma like this before in my life, and all the doctors say that the most likely reason and cause of the problems is the bad air here in Missoula. I grew up in St. Louis, the city of St. Louis, and in all honesty, I'm thinking of moving back because I think the air there is cleaner than it is here. I still enjoy climbing Mount Sentinel. It just always amazes me every time I reach the M and then finally get above the M to the very top, that I have sort of visions of the smog of the city that I grew up in, visions of time that I spent in Los Angeles and looking at the smog there, and I say, wait a minute, I came here 3 years ago to avoid all this. Why am I having to deal with it now? We know that there's an inversion layer here in the Missoula Valley. We know that pollutants and air toxins do not blow out of the valley, that they back up, they stay here, they condense. It seems just like an honest matter of common sense that you would not want to even have the opportunity to increase the number of particulates you can put into the air. All I can say is that I strongly oppose any amendment to the opacity levels in the SIP, and I would not ever wish having these problems that I have had to endure over the last 2 years put on somebody else. Thank you very much.
Okay. Brian Doherty?
Okay. I'd like to speak about an issue that I hope we'll be hearing more about this evening, and that is what is being emitted from Stone Container's Frenchtown Mill, and that is, among other things, dioxin. D-I-O-X-I-N. Many people in this room have probably never heard of dioxin, but I assure you that you will be hearing more about it in the near future. Dioxin is actually a general name for a group of approximately 200 chemical substances, all of them highly toxic. Most likely you've heard of a few of these substances. DDT, a pesticide banned in the United States in 1972, is a dioxin. Another dioxin, more widely known and more infamous, is Agent Orange. Dioxins are toxic, and they are produced every day in the Missoula Valley. The history of dioxin is an interesting one. In 1985, the Environmental Protection Agency published its first risk assessment of dioxin. This came on the heels of several important community exposures to the substance. Citing human and animal studies conducted over the course of the previous decade, the EPA concluded that dioxins represented the most toxic synthetic substance known to man and were a potential human carcinogen, unquote. Almost immediately, relevant industries began pressuring the EPA to reevaluate its findings and modify its conclusions regarding dioxin. In 1986, the pulp and paper industry joined the chemicals, plastics, and pharmaceuticals industries in pressuring the EPA when it was proven that the chlorine bleaching process produces dioxin. In 1991, the EPA began its first reassessment of dioxin and associated health risks. This report was expected to find that the dangers of dioxin reported in the 1985 report had been overstated. This has not been the case. Rather, the draft reassessment released in the fall of 1994 has elevated the risk of dioxin to the status of a, quote, probable human carcinogen, unquote. The report also noted that a number of non-cancerous health effects, including biological, immunological, and reproductive effects, are directly related to dioxin. Our most recent understanding of dioxin, in other words, has only magnified its danger. The report reads in part, "The weight of the evidence suggests concern for the impact of these chemicals on humans at or near current background levels." Dioxin is produced at the Frenchtown Mill. It is produced when chlorinated plastics such as PVC pipe are incinerated, and it is produced when the chlorine used in the bleaching process reacts with phenol, a naturally occurring substance in wood. Dioxin is in our air, it is in our water, and it is in our bodies. For this, we can thank Stone Container.
Karen Louise Ruff.
Hello, my name is Corinne Louise Roof, and I'm going to express two concerns on behalf of Women's Voices for the Earth, based here in Missoula. Here are our 2 points we would like to have put into the record. 1. Last May, the Montana Board of Health and Environmental Sciences, now the Board of Environmental Review, made a decision on a disputed rule change prior to holding a public hearing on the issue. Women's Voices for the Earth strongly supports citizens' involvement in all such decisions before any ruling is considered. Because this did not take place, we ask that the rule change be considered invalid. The public will not support or trust board decisions if we, the public, are treated without any respect or if we are systematically prevented from participating, as the law requires in fact-finding prior to decision-making. 2. Women's Voices for the Earth protests a decision being made by the board without consultation with local officials and agencies as required by the law. It is our understanding that our local Missoula City County Health Department was never consulted prior to the board's decision. This is a major problem. WEAVE supports local agency involvement in decisions that affect our lives and our health. Again, we request that the board's past decision is ruled invalid due to this point and the point we previously submitted. We must all work within the laws, and the Montana Board of Health and Environmental Sciences is no exception. Thank you very much.
Dan Serba.
Don. My name is Don Serba. I'm a lifelong resident of Missoula and a member of the Pulp and Paper Workers Resource Council, also from Missoula. In 1987, the City County Health Department conducted a study to identify the nature of the particulate in the Missoula airshed. This study used fingerprinting technology that identified the mill's 3 recovery boilers as a source of 4.4% of the total particulate collected in Missoula. During the past 10 years, Stone Container has invested more than $40 million on capital improvements, which have led to a 25% reduction in particulate from the mill and a 70% reduction in particulate from the 3 recovery boilers. The state permit of 1,253 pounds per day for number 4 recovery boiler does not come close to actual operating averages. Before the required 6-minute opacity monitors were in place, the average was 470 pounds per day. After the 6-minute monitors were in place, the average dropped to 215 pounds per day, resulting in an opacity reduction of over 50% from pre-July of 1994 through December of 1995, resulting in number 4 recovery boiler operating at approximately 1/6 the state permitted level. It is my belief that Stone Container has and will continue to reduce emissions from its Missoula mill as new technologies become available, and is operating well within state and federal limits. Therefore, I believe that the opacity regulations that the board adopted should be submitted to the EPA to update the state implementation plan. Thank you.
Ed Scott.
Good evening. My name is Ed Scott, and I'm the Director of Environmental Affairs at Stone Container. I would like to take just a couple of minutes to explain why Stone supports the action being proposed here tonight and why we think others should support it as well. The focus of tonight's hearing should be on the action that is now proposed, which is the incorporation of the state opacity regulations that apply to craft pulp mills into the Montana State Implementation Plan. We think the answer to the question of whether the state opacity standards for recovery boilers should be included in the Montana State Implementation Plan, or SIP, is clear, both from a regulatory perspective and from a practical perspective of what is good for Missoula's air quality. The new state rules should be included in the Montana SIP. Until the opacity rules for recovery boilers are submitted to the U.S. EPA for approval as part of the SIP, Stone Container and the public are faced with an illogical situation where one set of rules, the old state opacity regulations adopted over 25 years ago, apply as far as EPA is concerned, while the 1995 regulations apply as far as the state of Montana is concerned. It would make no sense to maintain this confusing and inconsistent situation. The issue here is not whether the State Board of Health and Environmental Sciences should have adopted the current opacity standards in May of 1995. The issue for today is whether the opacity regulations that the board adopted should be submitted to EPA to update the state SIP. It would make no sense to do otherwise. Nevertheless, it should help reinforce that conclusion to know that the effect of the 1995 amendments to the state opacity regulations has been to reduce Stone's air emissions. This may surprise those who have only heard of that the amendments to the regulations last year increased the allowable opacity for our number 4 recovery boiler from 20 to 30% opacity. In fact, there is much more to it than that. First of all, as we noted last year, our air permit specifies for each of our recovery boilers the maximum pounds of particulate matter we can emit per hour and per day. That number has not changed. The new opacity regulations that are now proposed to be included in the Montana SIP do not authorize any increase. Second, under the most stringent interpretation of the new state regulations, the allowable percent opacity has been reduced for 2 of the 3 recovery boilers. Our number 3 recovery boiler, which had been subject to a 40% limitation, is now subject to a 35% limitation, while the number 5 recovery boiler, which was subject to a 35% opacity limitation, is now subject to a 30% limitation. Finally, and most significantly, as Garen Smith indicated earlier, the revisions to the state opacity regulations that were adopted last year required for the first time that Stone continuously monitor opacity from the number 3 and number 4 recovery boilers. And they changed the method for determining compliance or non-compliance from visual observation to the use of a continuous opacity monitor. This change has had the effect of making any opacity limit significantly more stringent, as compliance is measured and recorded constantly, 24 hours a day, regardless of weather conditions or time of day, rather than only when a certified smoke reader is on site and physically able to get a good view of our stack. The effect of the new opacity limits and the requirement to monitor opacity continuously has resulted in substantial reductions in both opacity and particulate emissions. This is because the boiler operators now have a real-time continuous reading of opacity to meet rather than just the 24-hour limits. Therefore, they've been able to adjust the operation of the boilers and their emission control equipment to further reduce emissions of both particulate and opacity. As a result, opacity from the number 4 recovery boiler in 1995 was an average of half what it was in 1994. Also, the average particulate emissions from the number 4 recovery boiler, which are limited by our permit to 1253, that's 1,253 pounds per day, have fallen by more than 50%, from an average of 470 pounds per day in 1994 to an average of 215 in 1995. Particulate emissions from the number 3 recovery boiler, which were already quite low, also went down 20% in 1995. The bottom line is the current state opacity regulations have produced both lower average opacity and lower average particulate emissions. For these reasons, Stone Container believes that it would be in everyone's interest for the current opacity rules for recovery boilers to be incorporated into the state implementation plan. Thank you.
Jonathan Henning?
For the record, my name is Jonathan Henning. It's quite an act to follow. If nobody minds, I'd like to turn this around because I'd like to address the people of Missoula instead of a wall. It seems to me that Stone Container, in conjunction with the state, has broken the law, and the people of Missoula have been neglected. Stone Container is an easy target. They're a multi-million-dollar corporation, and I can walk over the Orange Street Bridge and see a plume coming towards Missoula, and it's really easy for me to point my finger and blame Stone Container. The problem is that Stone Container doesn't supply Missoula Airshed with most of its particulate, which the American Lung Association has pointed out is the major problem. I have some information that I've gathered from the Missoula PMT SIP. 47.3% of the particulate in the Missoula airshed is from street dust. It's from cars kicking up sand into the air. Another 44.3% is from wood stoves, residential wood stoves. Industrial sources are 5.8%. The same is true of carbon monoxide emissions in Missoula, which we know is toxic to humans. 63.8% of carbon monoxide produced in Missoula in 1990 has been produced by vehicles, another 26.1% by residential wood stoves, and industrial sources produce 9.6%. Stone Container puts dioxin into the atmosphere. It's carcinogenic. We know these things are also hazardous to human beings. When it comes to reducing the risk to humans living in the Missoula Valley, and when it comes to being healthy and breathing clean air, it resides on you and me. How many people here drove their cars this evening? How many will drive tomorrow morning, run some errands, drive again tomorrow night? I didn't see too many cars parked in front of this building when I came, bikes, excuse me, when I drove here on my bike this evening. It rests on us. We can point fingers and we can blame all we want. No one is listening. No one. It's us. We have to change this. If you'll excuse me for taking a quote from a very important speech, I have a dream, and I want to stand on the Higgins Street Bridge and see more cars and more people walking than driving. That's what I want to see. We can blame Stone Container when we ourselves stop producing things that are poisonous to us and breathing the air. I'm sick of riding my bike behind a car and sucking someone else's exhaust. Let's do something here, people. Wake up. It's not them, it's us. It's all of us. We buy the paper, we drive the cars, we live here. Let's change the way we live, and then we can complain about a company that does something like that. Thank you.
Ann Laurie, did I get that right?
Yes. For the record, my name is Ann Laurie. I'm a native of Missoula, born and raised. I feel uncomfortable now not addressing the mass audience because I have their interests at heart.
Go ahead, that's all right with me.
As well. Right. I was born and raised here. I did actually leave and come back, and that puts me in a strange position. I left and I made the choice with my husband to come back for family reasons. Older generations of the family are still here, and jeopardizing our health, I believe, by coming back and subjecting ourselves again to the air of Missoula. I love this town. I wanted to stay here my whole life. I see now that it's not a healthy environment for many reasons, as the young man has just said, for corporate reasons, as our respected health environment board members have said too, our elected and appointed officials. They recognize the corporate problem that Missoula has. I recognized it a little over 30 years ago when I left here. I have had respiratory problems since, I notice that they're much worse when I'm back here in terms of the strain to my throat and to my nose and respiratory system. It's unfortunate. I love the town. I have to be here for my family. I'm hoping that further years will allow us to make more improvement in the town and the air quality in this airshed. Thank you.
Louis Ball, is that right? You can move that podium whichever way you're most comfortable.
I think I'm going to be traditional. My name's Louis Ball, and it seems like some of the credits get for longevity in the Missoula Valley. I've been here for 35 years. I work on the ambient and source monitoring stations at Stone Container. I have done so for 16 years. My concern is for the information received by the operators and how it helps them to operate. With the new 6-minute averages versus the old 24-hour report, it will present current information to the operators so they can make needed changes. The old requirement is like having a speedometer in the trunk of your car and having to wait to the end of the trip to see if you exceeded the speed limit. When you erred in your speed estimate, you could be issued a speeding ticket and a fine for violating the law. Are we here to improve the environment or to issue tickets and assess fines? The operators change the parameters in the boilers or the kilns to reduce the negative impact on the environment. I have observed them use the information to operate better as they see the positive effects. They come to rely on the monitors to make the changes. These are very complex systems, and interaction may affect other parts of the system. We have good operators who, when given current information, will make changes to improve the environment in the Missoula Valley in which they live. Thank you.
Will Snodgrass? Is this my timer?
Good evening. For the record, I am Will Snodgrass. I'm president of Chemical Injury Information Network Montana. My address is P.O. Box 2885, Missoula 59806. And from the beginning, I would like to cut straight to the point. The SIP is woefully inadequate. In a recent radio debate, Montana Governor Mark Roscoe used the phrase reasonable and prudent. He was talking about the change in Montana's speed limit, which remains at 65 miles per hour at night. Governor Roscoe informed his radio audience that Montana drivers are reasonable and prudent, that they're not speeding at this time, even given the change in the limit. How true. Montanans also know that if they drive too fast, if they break the law, they will be fined. Their license will be taken away. In that vein, in looking at the records supplied by Stone Container to the state of Montana, and I'm holding them in my hand for the record, and using our speed limit analogy, we find that on October 9th, 1994, Stone Container was 25.7 over the limit, 81.7 mile per hour speeding. On October 5th, 1994, they were 49.7% over their pollution limit, 96.1 miles per hour if we're using the 65 mile an hour figure. On October 5th, 94, 100.6 miles per hour over the limit. Again on October 5th, another 100.6 mile per hour violation. October 5th again, 100.6. And again on October 5th, they almost made it under 100, 100.1, going on to June of 95, 82.29, 84.6, and on February 23rd, 3 violations for 97.9 miles per hour in terms of the comparison. It has been said that grandmothers and mothers are the best doctors in the world, that they can sense and know when something is wrong with their children. And in Missoula, mothers know that their kids are sick too much of the time. Governor Roscoe apparently does not know this yet. But if you want to talk numbers, which have been talked this evening extensively, and you want to talk about PM10, then perhaps Mr. Serba would like to talk about PM 2.5, because his numbers are wrong. His mill is producing about 12% of the fine particulate, which is damaging, most damaging to the human lung. If you want to talk about numbers, PM 2.5 to PM 0, which includes the PM10 range, then you're talking about molecular chemistry, not just particulate, but chemicals. What is really happening out at Stone? This SIP does not begin to address the physical and chemical realities of that facility. Did Governor Roscoe sign a SIP which is flawed? Most certainly, particulate, chemicals, hazardous chlorinated compounds from the burning of plastic create PM10, PM 2.5, you heard Mr. Alexander, and particles which are smaller than that, nearing the molecular level. Science tells us, Mr. Alexander has told us, that the SIP is inadequate. More importantly, personal and community experience tells us the SIP is inadequate. I would like to discuss this state implementation plan, the SIP, in terms of oversight and direction. And with respect to that area of government, we clearly see not only a problem, but a series of problems within Governor Roscoe's office. In fact, stemming from his desk and his pen. Using Governor Roscoe's reasonable and prudent argument as a lens with which to view Governor Roscoe's own performance, we see that Governor Roscoe has signed laws allowing increasing degradation of our living environment, degradation of water quality, legislation which also limits the ability of localities to protect their citizens from toxic compounds. Governor Roscoe signed such a law. Garen Smith, University of Montana Missoula Board of Health member, whom I admire greatly, is taking money from Stone, and he's clarified that for you. And as Mr. Best has pointed out, it becomes part of his resume, a saleable commodity. And as a professor of chemistry, Garen Smith knows things, or he should know things, which he conveniently does not tell this audience. Things about chemistry. Mr. Smith refers to some problems with the paper industry. Some problems, chemicals which threaten human reproduction, the organochlorines which the young gentleman referred to earlier. Airborne PM10 and smaller to the zero end of the scale, towards and including molecules such as the airborne dioxins, which Governor Roscoe seems so willing to overlook, so willing to allow in our air and our Montana water, are killing us. Clearly, poor oversight on the part of Governor Roscoe and Governor Roscoe's utterly poor choices are causing chemical injury to Missoula residents. Governor Mark Roscoe's obvious failures are marked by his signing of documents at the legislative level. In closing, we know what part chemicals are doing in the chemical hits upon living tissue. I know that the Missoula City County Health Department knows much of this. I believe the state of Montana also knows. I believe Governor Roscoe knows, by way of his advisors, what is going on in Missoula. And Governor Roscoe apparently knows where his bread is buttered. And in my opinion, he is being buttered on the backs of Missoula young and old. Clearly, the particulate level is linked to opacity. Contrary to what Mr. Scott has told you, increases in opacity are linked to increases in particulate. I believe I remember that from Mr. Carlson's testimony at the state level. Mr. Scott describes an illogic situation The situation is very simple. It's an emperor has no clothes clarity. One very important fact seems to escape Stone officials and their friends at the state. An increase from 20 to 30% is an increase in pollution. If they don't need it, if they're polluting less, why would they ask for it? Thank you. Don Serba's letter regarding dioxin is wrong. Test results were strangely missing from quarterly reports. Contrary to Mr. Serba's letter to the editor, dioxin was found in the bleaching process. While MCCHD has known, our health department, about the specific dangers of stone emissions, MCCHD has not warned this community about the real dangers of stone's emissions, nor has Governor Roscoe. Thank you. Sir, I have also been asked if I would submit some letters to a Mr. William Yellowtail, and I would like to read just the names of the submitters into the record. They are from a Marlene Haas or Hayes, H-A-A-S, a Timothy Bechtold, B-E-C-H-T-O-L-D. Also to Mr. Yellowtail, a letter from Jonathan Coop, C-O-O-P as in Peter, a Mr. Tom Platt, P-L-A-T-T, and a Mr. Bert Kraft, K-R-A-F-T, and a final one, John Stanton, and I will deliver these to you.
That's your written testimony? Okay. I think the last name is Folsom. I'm sorry, I can't read the first name. Last name Folsom? Oh, there it is.
I've been asked by Ms. Folsom to read her statement, which is very brief.
All right.
The technology exists to eliminate much of the poison that Stone Container spews into the air. Stone says it would cost them too much money to implement that technology. Why should Stone be permitted to increase their allowable emissions? To continue to poison the air I breathe, particularly when their corporate profits are big enough for them to give top executives one-time bonuses larger than the total amount of money I will make in my lifetime. Thank you.
Sue Spanky, did I get that right?
I'm Sue Spanky from the Advisory Council, but I'm on air quality, Citizens Advisory Council on Air Quality, but I'm just speaking in my own behalf. I think the lawful procedure is a very important issue in this case, but I feel it was well addressed by earlier speakers. Therefore, I'll simply address the issues of common sense and respect for the citizens of Missoula. First, in response to Garen Smith and several employees of Stone Container, I would like to say that if Stone Container is choosing to make a greater effort to monitor and control the pollution they expose Missoulians to, then I certainly applaud them. However, common sense and common respect say that the state of Montana should make ensuring the health of Missoula citizens its #1 priority. As we learn more and more about the inarguably deadly effects of pollution, a plan designed to lower particulate should certainly not raise a pollution source's allowable and therefore potential emission level. Thank you.
Is this David Avery? Did I get that right?
Hi,
Hi, my name is David Avery, and I'd like to begin by saying that I also represent one more individual who's not here, and that would be my 3-year-old son. He's at home with his 4th cold this winter. I agree with Ms. Hamilton that this is procedure is in some sense a sham. In any case, this is not being held in compliance with the things that took place in backroom dealings. It's more a retrograde, or this is how I feel, a retrograde attempt to put a good face on something that should never have taken place. That said, I'm going to, for just a second, forget that it took place and pretend that this is the actual hearing that should have taken place earlier in this year. Hi, my name is David Avery, and I'm representing a person who's not here right now. That would be my 3-year-old son who's had his 2nd cold this winter. We categorically feel that increasing the level of particulates coming out of stone container is unethical and unintelligent. Thank you.
Cedric Hames.
Good evening. I'm a 3rd-generation Montanan who was born in Missoula. I've been all over the world in personal travels, and I intend to live in Missoula the rest of my life. I can easily remember when this valley was badly polluted by wood smoke from many lumber mills in the surrounding valleys. Now all of that mill waste is being utilized by Stone Container in their manufacturing process. This valley now enjoys the cleanest air that it's had at least in my lifetime. I live on a nearby hill, and as I looked out over the Missoula Valley today, I enjoyed the clean air and clear vision as far as I could see in any direction. Stone Container employs hundreds of people whose wages support many businesses and civic organizations in Missoula. I am one of the many who support Stone Container and its continued effort to be the good neighbor they are. Thank you.
Ellen Leahy.
Ellen had to leave.
All right. David Ness.
Thank you. My name is David Ness. I'm on the Board of Directors of the Montana Environmental Information Center. The Montana Environmental Information Center, in addition to being an environmental advocacy group, also has been at the forefront of constitutional litigation in the state of Montana under our state constitution. As a resident of Montana and as a resident of the city of Missoula, I have a constitutional right to a clean and healthful environment, as well as a constitutional right to participate in governmental decisions and processes that will have an effect upon my life. It's my belief, and it's the belief of MEIC, that the state has not complied with either of these 2 constitutional guarantees. The state has a duty to maintain and improve a clean and healthful environment. In direct contravention to this constitutional guarantee, the state has lowered the opacity level for Stone Container. By lowering the opacity level for Stone Container, the state has, in fact, degraded the air quality here in the city of Missoula. It stands to reason that degrading the air quality in the city of Missoula will not improve and protect our environment. Through the state's decision to lower opacity levels in direct contravention to its earlier opinions, the state has served to violate both my right and our future generations' constitutional right to a clean and healthful environment. As I indicated earlier, the state has also failed to allow for citizen involvement before making a final decision to allow degradation of our air quality. Our state constitution guarantees both my right and the rights of the citizens of Montana to participate in processes and decisions that will directly impact our lives. The issue that's before you today is an issue of significant public interest, and yet it appears as though the state has worked on this case in reverse. in that it appears as though the state has already made a decision to allow the air quality in Missoula to become degraded and to increase the opacity levels of Stone Container without adequate citizen consultation. It is MEIC's desire that the state not make a mockery of these constitutional guarantees, that the state have respect for its citizens as well as future generations of this state, and it's our hope that the state will abide by these constitutional guarantees, not allow Stone Container to increase its opacity levels, and allow for adequate citizen participation by listening to the citizens here tonight. Thank you.
Dean Skaha? You might ask him to spell a name. I'm sorry, I wasn't sure I got it right.
That's a good try. Skaja, S-K-A-J-A. I've been a resident of Missoula for over 30 years. I've worked at Stone Container for almost 18, and something that people seem to forget